it's not only permissible for the courts to determine issues arising in the context of the Hague Convention, which include issues of risk under Article 13b, it's their exclusive role to do so. As both the Court of Appeal and the Supreme Court made clear in G, the fact that a child has been granted asylum means that any return order under Hague cannot be implemented. But crucially, this does not prevent a court from considering a Hague application on its merits, and even if appropriate, making a Hague Convention return order. Not only that, but as my Lord Justice Moylan made clear at paragraph 155 of the Court of Appeal judgment, determination of a Hague claim, even after a child has been granted asylum, has a real purpose. It allows the court to undertake its own evaluation of risk following an adversarial procedure in which the child is independently heard. And although any determination made by the court in this context will obviously not be binding on the Home Secretary, that does not mean that it will be irrelevant for the Home Secretary's purposes. It will be given proper consideration by the Home Secretary, and in appropriate cases, this may lead to the revocation or cancellation of the grant of asylum.
But what would this is the central issue in a way, what would any rehearing of the application under the Hague actually be looking at? They know they can't make a return order, or they know that a return order can't be enforced. So what issues would they actually be considering? Because until you know what issues they're considering, you don't know what disclosure is required.
Well, under the procedure set out by the Court of Appeal in the B case, which is in your Lordship's authorities bundle, there are really 4 stages to a...
What the stage is,
yes.
Whichever stage you want to put it, say you're in C or D, what will the judge actually be addressing his or her mind to? What question will they be doing? Will they be saying, was the Home Secretary right?
No.
Can't do that.
No.
So what are they doing then?
So the question number 1 is whether there has been a fundamental change of circumstances, such as to trigger the set-aside jurisdiction.
Yeah, assuming we're on to the reconsideration of the Hague application, as I said. So the judge is considering the Hague application. What issues does he or she address, given that we've agreed that it's not going to be, was the Home Secretary right to find that the criteria for the convention, the Refugee Convention, were met?
So what the court must then do, we submit, is consider whether in the present circumstances it should or should not make a Hague return order. So the original order has been set aside. The next question for the court is whether a Hague order, a Hague return order should be made, applying the principles set out in the 1980 Hague Convention. And of course, under the 1980 Convention, the starting point is Article 12, which provides that where a child has been subject to a wrongful removal, which is admitted to be the case here, the court is obliged to make an order for the summary return of that child to the country of the child's habitual residence before the wrongful removal, unless the respondent to the application, and the burden is on the respondent, can establish that one of the Article 13 defences is satisfied. And so, presumably in this case, the court would need to consider, first of all, whether the grave risk exception under Article 13b was satisfied. And as part of that evaluation, as has been made clear in many authorities, one of the crucial issues for the court would be the question of protective measures, because it's been held in a number of cases that Article 13b is a forward-looking exception. The court isn't so much concerned with the situation prior to the removal. It's very much about what is going to happen on the ground in the event that the child is returned to the state in question. And crucial to that determination is the issue of what protective measures are available to provide protection to the child in the event of return. And that they can be a combination of existing procedures under the law of the state in question, coupled with specific proposals that might be made by the left-behind parent to address any risks that are thought to exist.
But if you can't return the child, there's no point in spending time dealing with protective measures. They will be irrelevant. And you still have Article 20. I know Article 20 has not been incorporated, but we've got the Human Rights Act. And wouldn't another problem be that the mother would say, well, you just, whether Article 13 is met or not is relevant, because once there's the grant of asylum, right or wrong, Article 20 at the international level and Human Rights Act here would prevent you sending
well, my lords, we
back under Article 12.
We respectfully submit that so far as Article 20 is concerned, it was held by the Supreme Court in G&G that that did not really add anything to Article 13b. It did not, the issues under Article 20 fell properly to be considered within the confines of Article 13b, rather than it forming a separate ground of consideration. And so, I mean, the practical utility of a fully reasoned judgment we submit is twofold. First, it's that which was identified both by this court and identified by this court and endorsed by the Supreme Court in G&G, namely that a fully reasoned judgment can be considered by the Secretary of State, who would be entitled, depending obviously on what the judgment says, to look at whether it was appropriate to cancel or revoke the grant of asylum. And so that, that is one practical benefit of going through the exercise. In addition to that, we would respectfully submit that there is a further reason, which we haven't dealt with in our skeleton, so this is something I did want to deal with orally, as to why there is a real purpose in going through the exercise. Although Hague applications may be made by a parent directly to the court, conventionally what happens is that the applications are initiated through an overseas central authority. They are then transmitted to our own central authority, the International Child Abduction and Contact Unit. Under the terms of Article 7 of the Hague Convention, there is a requirement for central authorities to cooperate with each other to secure the return of abducted children. And among their specific duties, they're required to keep each other informed as to the operation of the Convention and to eliminate obstacles to its application. In many cases, including this case, the overseas jurisdiction will have primary jurisdiction over matters of parental responsibility in respect of the child, and may well be awaiting a decision in the Hague proceedings as to whether or not the child should be returned before they proceed to make substantive welfare decisions about the child. A fully reasoned judgment from a Hague court will assist the overseas authorities in understanding the basis upon which a child is not to be returned. It will assist them, for example, in deciding what steps it is next appropriate to take in the context of their own domestic proceedings. And the steps they could take might include a transfer of jurisdiction pursuant to the mechanism contained in Articles 8 and 9 of the 1996 Hague Convention, causing proceedings from the overseas court about the welfare of the child to be transmitted to this court. Now,
can you just, it's the words fully reasoned, which are very seductive, but what do they mean? The judge is sitting there. Does she go through the asylum file and say, none of these allegations are proven, or some of them are proven, but they don't amount to Article 13? Or does she simply look at the one-page letter without the annex that's come from the Home Office granting leave to remain for 5 years on the basis that the asylum claim is accepted? When you say fully reasoned, what is it that the judge is actually going to be looking at and forming a view about?
Well, in the context of a set-aside application, my lord, what...
No, I keep saying
Sorry.
Consideration of the application for Hague. Forget set aside, we've dealt with that for the moment. If she's considering, or he's considering the application in the context here, and you say fully reasoned, so we have a situation, she's set aside the order because there's a change in circumstance, and the application is outstanding, and you're saying it's going to help to have a fully reasoned decision.
Yes.
And what I know is what is going to be reasoned about.
So one would assume that in this case, two Article 13 exceptions are likely to be relied upon. The 13b exception and the child objections exception in 13.2. And so in considering each of those exceptions, the judge will have to have regard to the totality of the evidence. It's not the judge's role to, in the context of Hague, to make findings of fact about disputed allegations. And generally what judges do in this context, or the context of Article 13b, is assume allegations made by a respondent are true, and then consider whether risks arising from those allegations on the assumptions are true can be adequately mitigated through protective measures so as to bring the case below the Article 13b threshold.
So the judgment here is going to say, there have been these allegations, I haven't investigated if they're true, but if they were true, there would be these protective measures that would be put in place, but none of this is relevant because he can't be returned.
Well, the judge has set out all the allegations, and assuming that the ultimate conclusion was that the case did not meet Article 13b, the judge would inevitably have to say that, or record the fact that the Secretary of State, considering the same factual allegations through the lens of a different convention, has come to the conclusion that the child should be afforded refugee status, and that for so long as that remains, the child cannot be returned. But at least by going through that exercise, there would be some explanation and analysis of the underlying factual matters that were raised both in the context of Hague and which will have been raised in the context of the asylum proceedings.
In G&G, the assumption was, or because that was the factual situation that existed in that case, is that asylum claims and Hague claims would be running alongside each other.
Yes.
So that it was anticipated, I think, or expected, that the same material would be likely to be deployed in both, possibly. There's a question about that. But certainly there was, I seem to recall, an acceptance on behalf of the government that if they were running in tandem, that the material from the asylum claim would be introduced into or disclosed into the Hague proceedings through the child's guardian. Is my recollection right on that?
My recollection, my lord, is that what was suggested was that the child's guardian, or that one of the reasons the child should be represented
is they would have access to all the material.
Yes.
And then a decision could be made as to what should happen to it.
Yes.
I mean, not that it would automatically already be disclosed. If I said disclosed, disclosable.
Yes. So the child's guardian could act as a sort of filter.
Yes.
Look at the material and then make submissions as to whether it was appropriate for it to be.
But there was a recognition or an understanding that the asylum claim material might be relevant to the determination of the Hague application.
Yes, I mean, it's difficult to see how it.
And there was a recognition that even if the asylum claim was determined prior to the determination of the Hague claim, that there would still be purpose to the continued determination of the Hague claim.
My lord, yes, that's paragraph 155 of
Because, and that was endorsed by the Supreme Court,
It was.
because that might be additional relevant material for the Secretary of State to consider.
My lord, yes. I mean, I think.
So the question raised by this case is whether a later application for asylum after the Hague proceedings had concluded should lead to the adoption of a different procedure than that endorsed by the Court of Appeal and the Supreme Court in G&G. In other words, when they were, as was anticipated, because why would you not anticipate that would be made at the same time?
Well, my lords, we would respectfully submit that even in the context of the type of case with which the Supreme Court were concerned, they did anticipate that the re-B set-aside procedure could come into play following a grant of asylum that took place after the Hague decision. At paragraph 158 of the Supreme Court's judgment, I was going to come to this, there is, we say, specific endorsement of re-B.
Don't go out of you. You're dealing with general submissions. You're
Yes.
going to come
Yes.
more specific. I don't think we want to take you right out of your path. So do you want to, I think better perhaps if you continue with your general submissions rather than go off
Yes, of course.
to something that we're going to deal with later anyway.
Well, so, my lords, so the point I was going to come to is that, it's very important for the smooth operation of the 1980 Hague Convention and indeed the related 1996 Hague Convention that courts and relevant authorities should be seen to act in cooperation with each other. And so, even if the ultimate conclusion of the Hague Court is that after considering all the underlying material on a set-aside application, the Hague proceeding should be dismissed, or there's an explanation, there's an analysis of the underlying material, but an acknowledgement that the order can't be implemented until there's a change of heart by the Home Secretary. At least having that all set out in a judgment is going to be of some benefit in terms of being able to explain to the overseas authorities what has been going on here. Because otherwise, the central authority in Ukraine, or whatever jurisdiction one might happen to be dealing with, is entitled to ask for explanations as to why a child may not have been returned. And absent that sort of judgment, one is left with having to effectively say, well, for reasons we can't reveal, the child has been granted asylum.
No, but the authority abroad knows precisely why the child has not been returned, because even though two judgments said it should be returned, the Home Secretary has granted asylum on material that we don't know, and the child is not going to be returned because he's got refugee status in this country. What you're asking for is something more. You're asking for a judgment that says, we personally don't agree with that, the court.
My lord, no. We're absolutely not asking for that, but it's not the function of any court to question the decision-making of the Home Secretary.
Going to be said to the court or the authority in the Ukraine that isn't already clear from Mr. Justice Roberts' judgment. We know why the child is not going back. What you complain about is the decision of the Home Secretary to give asylum.
Well,
That's why the child is not going back.
Well, what, for example, you would have is a judgment considering the child's circumstances as they currently are, in the light of all the material that has been obtained since the Hague decision was made, in the light of protective measures that are now being proposed by the father to address the risks that are thought to or said to arise in the light of all that new material, and considering on a reasoned basis whether in the present circumstances any of the Article 13 exceptions are met, or alternatively, and if they are met, whether the discretion that arises under Article 13 should be exercised in favour or against ordering a return. And in terms of the promotion of cooperation between courts, we respectfully submit that is a better approach than merely communicating to the overseas authorities that, notwithstanding a judgment made over the summer 2020, in May 2021, the Home Secretary, for reasons we're unable to reveal, has afforded asylum or refugee status to the child, but we simply can't communicate to you any of the background information that may have led to that grant. I mean, that's but you, the overseas authorities, could infer that the Secretary of State's conclusion was the child's at risk of persecution in your country, and that your authorities are unable to afford the child proper protection. I mean, that's really the limit of what could be said, and to effectively leave the English authorities in the position where that really is the limit of what they can say, we submit is unsatisfactory in terms of the smooth operation of the convention and the need to promote cooperation between central authorities, and it's also inconsistent with principles of comity, between this court and overseas court, and the respect that should be afforded to the overseas court's processes, and the desirability of really being able to persuade the overseas court, if it's appropriate to do so, to transfer their welfare proceedings to this jurisdiction, so that the courts in England and Wales, if that is the desired result, can exercise their jurisdiction over the child. I mean, that's really what we say about that matter. I'm just skipping over some of my notes. I've already covered in discussion some of the points that I would have come on to deal with. So, one of the points we seek to emphasise is the timing point. The fact that the asylum claim was determined 11 months approximately after the Hague claim was determined. And so the circumstances being considered by the Secretary of State will inevitably have been different from the circumstances that were considered by the court in June and July 2020. One potential clear difference is that the Hague Convention return order in this case was crafted on the basis of protective measures which were designed to ensure that the child would remain living with the mother following a return to Ukraine until such time as the Ukrainian courts were able to deal with the matter on a welfare basis. Now, we don't know, but we would assume that within the context of the child's asylum claim, the mother is likely to have laid emphasis on the fact that in January 2021, a Ukrainian court at first instance made a determination that the child should live with the father. Now, although, as I've said, the decision was overturned returned by the Court of Appeal on the 19th of May, very shortly before the asylum decision on the 28th of May. We don't know whether that overturning of the decision will have found its way to the Secretary of State. But we, in addition to that, we also assume that the mother is likely to have relied on material, not placed before the Hague Court, to evidence an argument that the child's position in this jurisdiction had somehow hardened, and that the consequences for the child of a return were potentially worse. Now,
I don't follow that, because what the child thinks about whether he wants to stay here or goes back isn't relevant to asylum. You don't get asylum because you really don't want to go back. Indeed, you normally don't get asylum precisely because, or even if you don't want to go back. So I can't see how the child's objections hardening is relevant to the Secretary of State's decision on asylum.
Well, my Lord, I would respectfully agree that the mere fact that the child doesn't want to go back doesn't lead to the grant of asylum.
No.
But what I respectfully submit is that in considering a claim for asylum advanced on behalf of the child, the Secretary of State is bound to have regard to the interests of the child as a primary consideration.
Yes, but it doesn't help you to decide whether the child is at risk of persecution for a convention reason which the Ukrainian authorities are not able to safeguard against.
Well, my Lord, what I would respectfully suggest is that may depend on the nature of the material that is placed before the court. If, for example, the child is making, I'm having to speculate because I haven't seen it, but if the child is having to make further allegations, or is making further allegations against the father, is recalling events that have happened to him or her, or is articulating matters that are of concern to the child because the child feels they give rise to risk, one doesn't know. But that sort of material might well have some sort of persuasive effect.
That material may, if it demonstrates risk on a convention basis, yes.
But what we respectfully submit, my Lord, is that where there has been a change of circumstances, the procedure in Rule 12.52a is specifically designed to deal with that. And so where somebody is able to point to a fundamental change of circumstances, such as the fact that there has been an overseas court decision which changes the foundation on which a Hague return order was made, or other matters have come to light which fundamentally change the basis on which the Hague return order was made. That is the whole purpose of the procedure under Rule 12.5a. Can I move on then and make some specific points about that aspect of the case, what I've called the set-aside issue? When the matter came before the court in June 2021, that is to say the hearing before Mr. Justice Roberts, the children's guardian invited the court to set aside the original Hague return order on the basis that the grant of asylum required the Hague proceedings to be brought to an end by operation of law.
What does that mean?
Well, that's the subject
by
of
operation of law. It's bandied about. It's completely meaningless.
I'm not sure, my Lord, but it's an argument.
Anyway, you're
raised.
telling us that was the argument, that it came to an end by operation of law.
That is the argument that was advanced.
Yeah.
Was it the set-aside that was by operation of law, or the dismissal of the Hague application that was by operation of law? Or was it not clear?
Well, I think the way it was put was the set-aside, but I think, in fairness, probably what was meant was the set-aside. The court was required automatically to set aside and dismiss
Right.
the Hague proceedings. I think
So it must exercise its discretion under that relevant rule. It had no choice.
Yes.
That's what they meant.
Yes. I mean, that's the subject of the respondent's notice that's been filed on behalf of the child. The mother, notwithstanding what she may have said in her written submissions, supported the guardian's application in this respect, or the guardian's stance in this respect, and one can see their respective stances recorded in the judgment below at paragraph 31. We respectfully submit that the judge was entirely correct to reject the proposition that there was an automatic set-aside and dismissal by operation of law, because that proposition, in a nutshell, conflicted with what had been decided in G&G.
But, my Lord, this meaning is, operation of law means nothing else needs to happen. Because of a legal event, something happens. But that isn't the situation here, because the court has got to set it aside anyway. The order exists, unless an action takes place, i.e. the setting aside. So it can only be a factor mitigating in favour of exercising the discretion. It can't, by operation of law, remove the need for court decision, presumably. Yeah. Which is your point.
Well, I respectfully adopt that, my Lord. We also submit, my Lords, that the court was equally correct to deem a set-aside application to have been made either by the mother or by the child, because I mean this was the result that each of them was seeking to achieve. They just sought to achieve it on their own terms, as they would characterise it, by operation of law, rather than by means of a conventional procedure endorsed by the Court of Appeal in Re B.
Well, there's an extant order requiring the return of the child. So the court can't just leave it there.
Well,
the court has to decide what to do about that order, as you're saying, whether or not to set it aside, and then what to do in consequence of that. And that's your submission.
Yes, I suppose an alternative option would be to grant an indefinite stay of the order.
Yes, to do that, I suppose.
I mean, I recall in a very different context. Your Lordship may recall the 2001 case of TB and JB, which was all about Article 13B and an attempt to return 4 children to New Zealand, when an attempt to overturn the order was rejected by the Court of Appeal, but a stage was reached where the order became completely unenforceable. I think the tipstaff attempted to enforce it. It was met with sort of physical resistance by the children and backed away. And the Court of Appeal decided that the appropriate course in that context was simply to stay the return order. I mean, it may be less appropriate, of course, when one is dealing with jurisdictions that are both signatories to the 1996 Hague Convention, and given the way that convention is supposed to operate. But in principle, that might be an option open to the court. But I mean, certainly, we say that where really what a party is seeking to achieve is to set aside the order, that even if they come to the court and say, well, actually, I don't propose to advance that specific application because I want to avoid all consideration of the merits of the application. I prefer just to sit back and allow the situation to remain whereby the order simply can't be implemented because of the grant of asylum. The court, I respectfully submit, is entitled to look beyond that and say, well, actually, no, that's unsatisfactory. I'm going to deem you to have made a set-aside application so that the judge can look at this properly in the way that was intended in G&G, and in a way that's consistent with the procedure in Re B. Our real complaint, as my Lord identified, almost at the start of my submissions, is that having deemed the set-aside application to have been made, the judge really just dealt with the whole thing in this very, very summary way, setting aside, dismissing it, without going through anything resembling the normal procedure. And so in particular, there are no findings by the judge that any Article 13 exception is met. There are no findings by her, or there's no analysis by her, as to the exercise of discretion in an Article 13 context, and as to why it's appropriate to, exercise it in favour of dismissal. And that we submit as an essential part of the process, that it simply wasn't open to the learned judge to bypass. Having, in effect, having rejected the submission that the grant of asylum should lead inexorably to the setting aside and dismissal of the Hague proceedings, as what we sought to characterise as a tick box exercise, we respectfully suggest that the judge didn't really do very much more than that. There's certainly no reason given for her decision beyond the fact that the child had been granted asylum, and that really, on an application of the overriding objection, there was little point in, as she characterised it, allowing the proceedings to limp on.
Can you remind, where does the judge say that the grant of asylum itself is not sufficient to justify setting aside and dismissing the application?
Paragraph 60, really, but it says the opposite
yes.
of what you've just said.
Sorry?
Is it paragraph 60? But it seems to say the opposite of what you've
Oh, I'm sorry. It's the opposite. I was looking at paragraph 60. So, right at the top of page 115, in paragraph 60, I reject the submission made by Mr. Haynes.
Sorry, wait a minute. Yes.
And then she goes on to say further down, I can see the force of Mr. Haynes' GC's submission that captured at this particular point in time on the litigation continuum in the Hague proceedings, it may appear that the court's hands are tied in terms of delivering effective remedy to this father, but that without more does not, in my judgment, lead to the conclusion that, to use Mr. Harrison's phrase, consideration of his client's disclosure application is no more than a tick box exercise. The Court of Appeal has in turn rejected that position through its judgments in DNRH, and then she refers to the set-aside procedure under Rule 12.52 and the fact that the Supreme Court in G&G has confirmed that the court retains a power to review and set aside a final order.
So on this first point, you agree with that, but you say that what she did was not very much more than that, because she operated on the basis, well, the child's got asylum, so that's that.
My Lord, precisely so.
And that's the paragraph 76, really, isn't it? The little purpose, he says, by allowing the convention proceedings to limp on,
Yes.
without further purpose or effective remedy.
Yes.
And she says there be a further round of written statements, and I ask myself, what will inform the content of those statements? is really the question that I've been asking you. What would the judge be asked to be looking at and why?
Yes. And so, my lords, one of the arguments raised against me is that whereas the Supreme Court did refer to re-B and the ability of the court to set aside orders, it does not follow from that the Supreme Court had in mind anything more extensive than a virtually automatic setting aside of the order in circumstances such as these. We respectfully submit that submission that is made against us doesn't sit easily with paragraph 158 of the Supreme Court judgment, which is on page 79.
Should we go to that?
Thank you. It's page 796 of the decision.
Sorry, can you remind me which tab it is?
It's tab 11. And whilst I'm there, can I apologise, because I think in error in the index.
Case 4
Case
is
4
is not as advertised.
Correct.
That's not uncommon. That's usually a way in which the parties try and test to see whether the Court of Appeal have read the document. But certainly, speaking for myself, that was a test that I did pass.
Grateful, my lord.
Because the case behind tab 4 is Mr. Justice MacDonald on disclosure.
Yes, it's the first instance decision in RH.
So you want us to look at 158 on page 415?
Electronic 415, yes. And the
Real world 415.
I'm sorry.
Real world 415.
Real world too.
But on a piece of paper.
Yes. So, I mean, we suggest that the language used there by Lord Stevens, and I'm conscious of the fact that making the submissions that we're not obviously dealing with a statute, but nevertheless, the language they used doesn't suggest that what the Supreme Court had in mind was that they would simply, that it would sort of automatically follow that after a grant of asylum, a court would simply set aside a Hague order. And we rely on the fact not only that re-B was specifically endorsed in that paragraph, but also the reference to the fact that if a result of the decision of the Secretary of State in relation to the asylum process, a reconsideration of the Hague Convention proceedings is required, then the court has the power in England and Wales under 12.52 or the inherent jurisdiction to review and set aside a final order. All of that we submit suggests that what they had in mind was investigation rather than automatic dismissal.
You've got 157 before it, which says the one thing you don't do is look at the asylum. So again, I'm asking myself, so does the judge say, well, I'm not going to order disclosure of the asylum file because I'm not looking at asylum? Or does she say, well, I will order disclosure of the asylum file and I'll go through all the allegations there and I will see not whether they justify asylum, because that's not for me. I will see whether those justify a finding that Article 13b is not met. And then I'll give my judgment and I'll say I've read all the file, I've looked at all the allegations. Article 13b isn't met, but I'm not going to order enforcement because there's no purpose, because another body is taking the view that there'd be a risk of persecution and I can't enforce the remedy, so there's no point in making it. Is that the kind of exercise you're anticipating would happen?
More or less, my lord, yes. Yeah. But what we would submit is that at the disclosure part of the exercise, the task of the court is to consider the relevance of the asylum material
to the Article 13 issue.
Well, to the Hague issue.
Because that is what the court is deciding.
Yes.
The court will have to say, is it relevant to Article 13b? But you also say, well, even if it were relevant to Article 13b, whatever I find on Article 13b is ultimately not going to assist me, because ultimately I'm going to refuse this order because I can't enforce it.
Well, to Article 13b or any other Article 13.
Or any other issue, yes, but don't dodge the question by
No, what?
shortcut.
No, I'm sorry, I'm
Could
not saying.
she say, I'm not going to order disclosure for any articles under the Hague Convention because ultimately I know I'm going to refuse to make an order because I know, whatever my private thoughts are, I can't have it enforced.
Well, we respectfully submit that would be the wrong approach, that what the court should do if it decides that the material is relevant to any Article 13 issue is apply the test articulated in cases such as Dunn and RH, conduct the balancing exercise, but ultimately only refuse disclosure if it is strictly necessary to do so. Otherwise, disclosure should be ordered. And the court should certainly not, at that stage of the procedure, we submit, prejudge what its ultimate conclusion is likely to be in relation to the...
We know what the conclusion is going to be. We know that she can't enforce any order or have it enforced. So the first issue is, will I make an order, whatever the Article 13 issues, if I know it can't be enforced? Would that be wrong? And then we should say, well, I don't need... it's not necessary for fairly and justly disposing of the issue, should I make an order under Article 12 of Hague, because it's not going to be necessary for that, because she's not going to make it, for the simple reason that it's not going to be enforced.
Well, I mean, we respectfully submit that to adopt that approach would be inconsistent with what was commended in G&G, which was, in our submission, to the opposite effect. Where even though there has been a grant of asylum, it is entirely permissible for the court to proceed to make a return order after undertaking its own evaluation, to give a fully reasoned judgment within the four corners of Hague, and then it's really a matter for the Secretary of State to consider it and decide whether or not, she wishes to maintain the grant of asylum or revoke it. I mean, that's the approach we submit that was commended in G&G for very good reason, because it's all part of ensuring that the two instruments march hand in hand, and it's also important, we submit, because an asylum process in which a decision maker is making decisions of fundamental importance about a child where one parent is excluded from the process could be said to be unfair. And therefore
I understand that, I see the force of that, but it doesn't help the judge dealing with Hague. She can't say, I'm going to do lots of things under the Hague because I don't like the statutory system for dealing with asylum.
Well, my lord, not
She's
for that.
never going to consider under Hague refugee convention issues.
Not for that reason, my lord, but the fact that a parent can participate, or both parents can participate in a Hague context, but not in the other context, it is one of the reasons why it was held in G&G to be of importance that this twin-track procedure, which is all about ensuring that the two instruments march hand in hand, should be maintained. They
can't march hand in hand ultimately, because if the one says you can't return, that trumps the ace of spades.
Yes. I mean, yes, I can't get around that fact. That's
if we look at what Lord Stevens said in paragraph 156, he in the middle, he's talking about the relationship between the two, and he says, in this way, an exclusive focus on the merits of the Hague Convention proceedings must, in certain cases, also require consideration of the facts giving rise to the claim for international protection. So there's a recognition there that evidence advanced in support of the asylum claim must be considered by the Hague Court. For the purposes of ensuring a proper and fair, I'm interpolating, determination of the Hague case. And I think he then goes on to consider in the passages dealing with practical points, what we were discussing before, the provision of information about the asylum claim into your disclosure into the Hague case, and that's why I thought actually it might be helpful for the Secretary of State to be joined as a party to those proceedings. But can you, while we're here, can you write what was said in the Court of Appeal about the purpose and efficacy? I'm sure we're taking to us, but would you mind going there now about a Hague decision, even in the face of a decision to grant asylum?
My Lord, yes. So, bundle page 369, page 155 of my Lord's judgment.
There's actually, I think, the judgment of the court, but anyway.
Oh, I'm sorry.
Paragraph 155.
Yes. Roman 1 is probably of less relevance because in Roman 1, the court was there dealing with the situation where a claim has been made by the parent.
Yes.
As opposed to the child. But of more relevance is Roman 2. If the child has been granted refugee status or has an independent asylum claim pending, then a return order could not be implemented because that would breach the prohibition. However, even in those circumstances, there are additional reasons why it could well be appropriate for the court substantively to determine the application. In summary, this is because the differences between the two processes set out in paragraph 144 above, in particular the participation of the left-behind parent and of the child. The 1980 Convention is expressly designed to give the left-behind parent access to justice and to ensure that the voice of the child is heard. Further, the differences in processes might lead to different conclusions being drawn. Then Roman 3 is the paragraph, I think, in which the court set out its conclusion that the court should be slow to stay Hague proceedings.
Right.
Of more relevance is Roman 4, just as a reasoned decision on an asylum claim, if available to the High Court, will be relevant in the subsequent determination of an application for a return order, a reasoned High Court decision on the evidence available to it, which will very likely be different from that available to the Secretary of State for the reasons we've explained, and tested to an extent by the adversarial process not available in the assessment of an asylum claim, could be expected to assist the Secretary of State in determining an outstanding application for asylum, while not creating any form of presumption. Depending on the nature of the respective applications and defences, the earlier decision may not only be relevant, but possibly of some considerable weight. That may be particularly so where the risk being assessed in each exercise is similar in nature. And then 5...
The problem here is the Secretary of State had two judgments and came to a different conclusion. What you really want is a third judgment saying, still not good enough, revoke. That's the reality of what you want to do. Unless you can get that decision revoked, the child isn't going to go back.
Well, I respectfully agree with your Lordship's last point.
Yeah.
But I mean, as to the two judgments, well, the first judgment was made in the context of an earlier wrongful removal.
Yeah.
And I mean, the second judgment, I've already made the point. It was made 11 months before the, consideration of the case occurred 11 months before the asylum decision, and the Secretary of State had available to her material that was different from that which the Hague Court had considered.
And you want the Hague Court to express a view on that material now, hoping that you change your mind. That's the reality of it.
Yes. We would like the Hague Court, within the confines of the Hague Convention and the set-aside jurisdiction, to undertake an analysis as to whether the Article 13b exception is met, and to undertake an analysis as to whether the child's objection exception is met. It probably is met, given what we know, but to consider whether, despite it being met, it is appropriate, having regard to the different matters that the court is required to take into account in the exercise of discretion, it's appropriate nevertheless to order a return or not. And I mean, that may require the court to express views about the child's best interests, which is one of the factors that in a Hague context the court has to take into account as part of the discretionary exercise. So, my lord, yes, and we would like that analysis, and obviously the father doesn't want a Pyrrhic victory. I mean, ultimately he would like to secure the return of his child. So obviously his ultimate ambition is to persuade the Secretary of State to change her mind and revoke the decision. But it's unfair to criticise him for wishing that as an ultimate goal when what he's proposing to do is to go about it by legitimate means which have been given proper endorsement by the courts in G&G.
And just picking up that submission as I understand it, is that you're saying that the material that was relied on by the mother in the Hague case is, we are assuming, different from the material relied on her in support of the asylum claim. And that material has never been deployed in support of the Hague case or considered by the family court. And there's an argument you're saying that for the proper determination of the Hague application and the proper determination or fair determination of that material should be not deployed just in one forum, but should be deployed in both forums.
My lord, yes.
Because otherwise there's a partial advancing of a case in one forum and a different case being advanced in a different forum. And that might be thought to be using the different opportunities for different purposes.
Well, my lord, with respect, yes. I mean, it really undermines what was intended by the courts in G&G.
Had you finished? Were we going to paragraph 5?
I was going to go to paragraph 5, yes. So paragraph 5, the Secretary of State is under an obligation to determine an asylum application in accordance with the immigration rules where that status has been granted, but the court has determined that the return order should be made. Before us, the Secretary of State, through Mr. Payne, in our view rightly, acknowledged that as a result of paragraph 339J3 of the rules, if nothing else, she would be under an obligation to reconsider refugee status. The Secretary of State also confirmed that where requested to do so by the High Court and recognising the State's duty to expedite the Hague process, whilst always acting consistently with her substantive and procedural obligations to apply anxious scrutiny, should use her best efforts to prioritise consideration of a pending asylum application or whether to revoke a grant of asylum in the light of the High Court decision and any material obtained during the 1980 Hague Convention proceedings. In those circumstances, the determination of an application for a return order by the High Court will usually have some real point, even where the relevant child currently has refugee status.
Can you remind me, where does Lord Stevens deal with the involvement of the Secretary of State in the Hague proceedings? It's 166, yes.
Yes,
she joined as a party for the first two judgments, the Secretary of State.
I'm sorry, my lord.
Was she joined as a party or an intervener at the time of the first and second judgments, Theis J and Robert P. or QC?
She was not an intervener at the time of the Hague proceeding, the original Hague proceedings, either the first round or the second round. At that stage, my lord, there'd been no asylum claim made on behalf of the child, so there would be no basis.
Yeah.
The asylum claim was not made until October
The 20th, and possibly received on the 2nd of November. Yeah.
And I think what you're saying, if the asylum claim had been made prior to the determination of the Hague case, then looking at what was said in G&G, Lord Stevens said must in some cases, but certainly the court would have analysed whether for the proper determination of the Hague case, the asylum papers needed in some form or other, maybe redacted, maybe not at all, depending, needs to be disclosed into the Hague and will be provided to the child, certainly, to assist with that.
Yes, and then I mean the court would ultimately have to go through the Dunn and RH exercise to decide whether they should be fully disclosed to all parties in the Hague proceedings.
And it's dealt with, I think, in paragraph 163 of the Court of Appeal's judgment, that the child should be joined as a party whenever an asylum claim has been made. And then it goes on, this applies equally to circumstances in which the taking parent and or the child have been granted refugee status. And that has all been circumvented in this case because the asylum claim was not made until after the conclusion of the Hague proceedings.
Yes, I mean well after the conclusion of every court-based attempt to prevent the order being implemented had been exhausted.
Yes, thank you. Yes.
So, I mean, I wasn't proposing to specifically go through it, other than give your lordships the reference. But the reference in Re B.
Is there anything more you want to take from G&G?
Not at this stage, my lord.
No. Sorry, yes, B.
In Re B, the set-aside case, paragraph, I'll give the court the paragraphs. Paragraph 83 is when my Lord Justice Moylan referred to.
Sorry, page.
Oh, it's page B227. Tab 7.
Yeah.
It's paragraph 83 where the court referred to fundamental change of circumstances being, in effect, the trigger condition giving rise to the possibility of a set-aside application. At paragraph 86 onwards of the judgment, there's an analysis of the structured approach that needs to be taken when dealing with a set-aside application. And the court's conclusions about the 4 stages are at paragraph 89 of the hearing. And whilst it's possible to roll the 4 stages up into one hearing, normally the normal expectation is there would be 2 hearings. And obviously, I mean, it's clear from that even if an order is set aside, it doesn't necessarily follow that on a subsequent reconsideration, the Hague application will be dismissed. What I would respectfully add to that is that the court also is not necessarily confronted with a binary situation. In other words, it's not reconfirm the original Hague order or dismiss the proceedings. It's open to the court to make a new Hague return order on the basis of a different package of protective measures tailored to meet the new circumstances.
How could you ever make any return order, even with different protective circumstances? Because even if you promise not to do all the things that are against the convention, if there's a grant of refugee status, that's it. Because it's based on the assumption that the person wouldn't be protected by the authorities in the state concerned.
Well, I mean, what we say is that the court can't obviously interfere with the grant of refugee status, but the court
I can't enforce any order.
while that status subsists, it can't enforce any order, but what it can and should do, for the reasons articulated in G&G, is undertake its own evaluation.
It can say it wouldn't have met the threshold for Article 13b. It can say that without any difficulty. But at the end of the day, no matter what it says about protective measures, they aren't going to be capable of helping, because protective measures are only good if they're enforced, and inherent in the asylum claim and decision is that you can't rely on the state authorities and the state concerned.
No, well,
there's not going to be a way of getting around the asylum decision by protective measures. All that you're going to have is a decision that on the same material, Article 13b wouldn't have been met.
yes, but what we respectfully submit is that part of the court's analysis as to whether Article 13b would or would not be met includes consideration of available protective measures. And it's open to the court to say, I, the judge, consider Article 13b would not be met, provided A, B, C, D, and E protective measures are in place. And A, B, C, D, and E may be different in the context of a set-aside application from, what might have been A and B in the context of the original Hague process. Now, I obviously accept that even by specifying that A, B, C, D, and E should be put in place, and even if they are offered, and they can include all sorts of things. They can include an invitation to the left-behind parent to go to the local court and obtain an order confirming that the child lives with the mother and for an indeterminate period. There isn't really any restriction on the sorts of protective measures that could be imposed in this context. But where they might be relevant is that inevitably the Secretary of State will be sent the court's judgment, and she will then be in a position to give consideration to the court's reasoned decision, which will have included an analysis of the protective measures that are going to be in place for the child, and that might inform the Secretary of State's view as to whether within the different context of asylum that she is considering, the basis for the grant of refugee status remains sound in the light of what is actually proposed on the ground. Can I move on from that topic to deal, I hope, relatively quickly with disclosure? We respectfully submit that the test for disclosure is now well settled in the Dunn case, recently reconfirmed in the context of asylum in RH, which is at tab 6 of the authorities bundle. The court must first consider relevance, whether the contentious material is relevant to the issues in the case, and if so, the court is required to undertake an exercise which involves balancing competing rights, but ultimately the court should only refuse disclosure where it's strictly necessary to do so, because the importance of disclosure to a fair trial. In this case, at paragraph 69 of her judgment, Mr. Justice Roberts accepted that the material had some relevance to the set-aside application. This is the paragraph where she also said the basis of the application for asylum was anchored to the Article 13b defence, which the mother had run in the proceedings. She pointed out that the father was aware of the Article 13b defence that had been run, and also acknowledged that there was an inconsistency between the information placed before the Secretary of State and that which had been placed before the Hague Court. And she said in that paragraph that it was reasonable in principle for the father to see the material, to know the case advanced against him. at paragraph 73, Roman 2, the learned judge referred to the weight to be attached to the different rights engaged in the exercise, but we respectfully submit that she didn't actually make a finding that it was strictly necessary for this material to be withheld from the father, let alone explain why this was so. In our respectful submission, in circumstances where the claim the child M had made for asylum was, as Mr. Justice Roberts put it, anchored to the case previously run by the mother in Hague proceedings under Article 13b, about which the father was fully aware, and where additionally he was aware of that independent social worker report that had been generated since the original proceedings. We submit it's very difficult to see how it could be said to be strictly necessary to withhold the material from the father. I mean, it's very difficult for me to go beyond that, not having seen the material. The mere fact that a person has deployed material in support of an asylum claim does not, of course, mean that the material is so inherently sensitive or confidential that it meets that test of strict necessity. We, of course, accept that as a general proposition there is a public interest in maintaining the confidentiality of asylum claims, and accept that in many cases it's essential that the alleged perpetrator of persecution should not even be informed that an asylum claim has been made, let alone provided with details of the claim or the underlying material. But in a case such as this, where the father is already aware of the thrust of at least many of the allegations levelled against him, we respectfully submit that the public interest in maintaining confidence in the asylum process may well attract less weight than the public interest in ensuring that proceedings about a child are resolved fairly and that on the basis of all relevant information being known to both parties. The relevance, we say, as a general proposition, of a father being an alleged perpetrator of persecution is that the strict necessity test articulated in Dunn and RH may more easily be satisfied in those circumstances. But everything must depend on the particular facts of the case. And there is certainly no rule or even presumption against disclosure to a person merely because they are the alleged perpetrator of persecution. At paragraph 53 of the skeleton argument filed on behalf of the Secretary of State, my learned friends, in effect, propose a new test for disclosure.
Sorry, can you give me the paragraph?
Paragraph 53, and it's in the core bundle at page 88.
Thank you. Yes.
I mean, we respectfully submit that what is suggested there is contrary to two Court of Appeal authorities, Dunn and RH.
You haven't even been given the letter. There's normally, and there would be all the letters and material that the mother provides, which is one part of the file, but there's usually a decision letter giving reasons why the person's been granted asylum, and I didn't understand that that was normally confidential. I've seen lots of them, but maybe it is that they're normally confidential.
My lord, it isn't, but if you remember, sorry, if you recall, my lord, when grants for asylum, it's two-line letter effectively saying you've been granted
With the
asylum.
reasons attached, yeah.
No, not necessarily in terms of a grant. It's the refusal where the reasons are set out in detail.
Right, so do we know anything? Do we know if this is just 2 lines, or can you not even tell us if it's 2 lines?
My Lord, I will check.
Right. Because it's hard to see why, if you've granted it, why it's not like a court judgment or a public document.
Well, my Lord, in terms of the confidentiality of the information underlying the material, that may well be a reason why they aren't set out in a document. But also it doesn't, because there isn't a right of challenge to the grant of asylum. Certainly in my experience, I can't remember a letter that I've seen where the reasons are set out.
Right, it'd be interesting to know whether it is just 2 lines, if you can even tell us.
Of course,
2
ma'am.
lines saying that M has been granted asylum from X
Absolutely,
date, 'cause
ma'am.
there will be something granting indefinite leave to remain, you see, for 5, granting discretionary leave to remain for 5 years.
Yes, my Lord, and there'll be 2 separate letters. There'll be one in terms of the grant, just in terms of the status, and there'll be another one in terms of the grant. But again, certainly in terms of the grant of leave, that is just a 2-line letter. But I will
That's just
confirm
2
it.
lines, okay.
Well, at paragraph 52 of
Sorry, of
Moylan Friends skeleton
Yes.
argument, I mean, various references are made to extracts from G and G, and presumably in support of the submission that Moylan Friends seek to make at paragraph 53. I mean, we respectfully submit that one needs to be a little bit cautious about looking at those extracts from G and G in isolation, really for 2 reasons. First of all, questions of disclosure were not the subject of the appeal to the Supreme Court in G and G, and therefore, strictly speaking, the observations made by Lord Stevens in that context were made over diction without hearing full argument on the issue. But also, it's clear in any event from the judgment in G and G, and I mean the reference is the last sentence in paragraph 170 of the Supreme Court decision, that Lord Stevens made clear that he was not suggesting there should be any departure from the test articulated in Dunn and RH. I mean he referred at paragraph 170 to the need for the court to apply that test. And so,
sorry, paragraph
170 of
170.
170, yes. And so, these little extracts need to be treated with a bit of caution in my submission for those 2 reasons.
I mean, maybe the way in which the case was advanced before her, but Mr. Justice Roberts looks at it, or appears to look at it, exclusively from the perspective of the set-aside application, not the redetermination. Does that reflect the way in which the case was put, and is it unfair on her to me to describe her judgment in that way?
But it's possibly a bit unfair because I think we were probably all guilty of the same offence of talking about the
everything as set aside.
Yes.
Yes. Okay.
My Lord, so the secondary submission we make under the heading of disclosure, I mean, the first is that even if the judge was correct to have, dealt with the set-aside application in this ultra-summary way, and even if, she should have upheld Moylan Friends' operation of law submission, we submit she should still have ordered disclosure of material to the father unless the test of strict necessity was satisfying. Ultimately, it is the Secretary of State's decision that is preventing the father from enforcing his Hague order. I mean, the 2 are inextricably linked. And, I mean, we submit that if that strict necessity test is not satisfied, then surely the father is entitled to know and understand the reasons why he cannot enforce his Hague order beyond simply the bare communication of the fact that the Secretary of State has granted his child refugee status. Furnishing him with that knowledge will allow him to understand why he is where he is, and and from his perspective, will
That's
have.
not going to be the purpose of this application. It's not to do that. I thought it was to decide whether if you set it aside because there's a fundamental change of circumstance, then you're going to have the considerations to whether the various articles apply. It's not a means of imposing a duty to give reasons for the asylum decision. The disclosure is relevant to whether or not the Hague Convention grounds are made out. I thought you were saying.
Well, my lord, that is our primary case.
Yeah.
Yes, but
Then it can't be right to say, in a perfect world, the statutory process for asylum would have a duty to give reasons to the parent of a child. There isn't one. Therefore, we'll do it in the convention proceedings instead, so the parent can get what Parliament has decided he shouldn't get in the asylum.
Well, my lord, I mean, in an ordinary case where there's no, there are no related asylum claims, and obviously, a court has to explain to the losing party why they have lost. Why they've been found against. And so,
the Hague Convention is not a way of forcing the Secretary of State to say to a father, you're not going to be able to get access in the Ukraine to your child.
well, I can tell my lord's against me on this, but
But the two others we haven't heard.
really, the submission we make, my lord, is that because the two processes are so inextricably linked, and because the Secretary of State's grant of asylum is the very reason why the father is unable to seek implementation of the Hague order. In that context, absent meeting of the strict necessity test, he should be entitled to know why, this decision of fundamental importance to his child has been made, and it will have the practical benefit of affording him knowledge to enable him to make decisions about, where he should go from here. Should he continue with the proceedings in the Ukraine, or should he seek a transfer of those proceedings to this jurisdiction? Should he, make a welfare-based application in this jurisdiction, and what should it be? It has very real practical relevance to him, and because the two are so linked, we say, there should be disclosure in any event. But that's not our primary case. That's our secondary case.
Thank you.
And that really is, it's not unfair to describe it as a jury point. It may be quite a powerful jury point. Really you're saying the father's lost and nobody will tell him why, and everybody says it's confidential. How can that possibly be right in an English court in the 21st century?
Yes.
That's the point. That there are authorities as long as your arm about how judges have to give careful reasons for every decision. And this would have the effect of the father losing the Hague Convention claim without ever knowing why.
My lord, yes.
And whether it's more than a jury point will be for us to decide. But that essentially is the point.
Yes.
How can that possibly be right?
Yes. So, if the Court of Appeal allows the appeal, then the order we invite the court to make is that the matter should be remitted. We're not asking the court to determine the disclosure issue. We say it should be remitted for an urgent case management hearing, at which questions of disclosure could be considered afresh, and the matter could be timetabled to a set-aside and reconsideration hearing in accordance with Re B. I want to just, before I sit down, respond to some specific submissions raised on behalf of the Secretary of State in their skeleton argument. At paragraph 44 of the document, and in subsequent paragraphs, they raise issues relating to what are termed asylum policy considerations. And at paragraph 44, my learned friends submit that it would cause significant damage to the asylum process if what they characterise as fresh hearings were routinely held in the context of Hague proceedings. I would respectfully make 3 points in response to this. First of all, out of the large volume of asylum claims that are received each year by the Secretary of State, those which have related Hague proceedings represent just a small fraction, and those which have Hague proceedings in this sort of category, where the asylum claim is made after the conclusion of the original Hague decision, are a fraction of a fraction. Second point, contrary to what is suggested in paragraph 45 of my learned friend's skeleton, it's not the case that holding a conventional set-aside hearing will inevitably result in disclosure of confidential material. It's a decision to be made on a case-by-case basis, applying the Dunn balancing exercise and the test of strict necessity. And a third point I would make is that these cases are in a special category because they engage two international instruments to which the United Kingdom is a contracting party. We submit that the process we are advocating for this special category of case will not have any material impact on the general system of asylum. On the other hand, allowing return orders to be set aside and proceedings dismissed without a fair adversarial procedure is likely to undermine confidence in the United Kingdom's adherence to the 1980 Hague Convention. And as I've already submitted, it also runs contrary to principles of comity to refuse to return a child to a country which has primary welfare jurisdiction without providing a proper explanation for the decision. The next point to which I would seek to respond is that advanced really from paragraph 37 onwards under the subheading Utility of a Fresh Hearing. My learned friends are there seeking to revisit the proposition that was accepted by the Home Secretary in G&G, as we saw in the passage we looked at paragraph 155, Roman 5 of the Court of Appeal judgment, to the effect that she would be under an obligation to reconsider the grant of asylum in the event of a judgment from the court ordering the child's return under the Hague Convention. The argument now advanced by my learned friends, which wasn't advanced in either G&G or in the Scottish case to which they have referred, is that the circumstances which could lead to a revocation in this context are, to quote what they say, extremely limited. Now, I respond to this point with due deference to my learned friend's superior knowledge in this area of the law, but nevertheless submit that they may be overstating the position. The Refugee Convention in paragraph 1c provides for a reconsideration of refugee status where there is a change in circumstances such that an individual no longer needs protection. This is reflected in the policy document which my learned friends have provided to the court at tab C1 of the authorities bundle, and in particular at page C430 of that bundle under the subheading 2.1, the Refugee Convention. My Lord, see there.
Sorry, see what?
C430 is the page reference. It's the penultimate tab in the authorities bundle.
Sorry, what is this? This is the asylum policy instruction.
Yes, about the revocation of refugee status. There's a specific reference on page 430 to Article 1C of the Refugee Convention. And that provision has also been transposed into the immigration rules at paragraph 339A Roman 5, which, for ease of reference, is quoted by my learned friends on page 12 of their skeleton argument.
But hang on a moment. 339A5 says they can no longer, because the circumstances in connection with which they have been recognised as a refugee have ceased to exist, continue to avail themselves of the protection of the country of nationality. But this is, we're here dealing, aren't we, with a different situation? It's not that the circumstances have ceased to exist, the government has changed and the new one is more favourable. Here we're dealing with a situation where you'd like one body, the court, to say to another body, we don't think these allegations really stack up as a matter of fact, and therefore we're going to say Article 13b isn't met. You might like to think about whether or not you should have granted this in the first place. That's the exercise really, rather than setting aside, isn't it, because of a change of circumstances?
I'm forced to respond to that, obviously, in the abstract, without, knowing the basis.
Without knowing the facts, yes.
But I mean, one obvious, potential change of circumstances may be the fact that, I simply don't know, but it may well be that the Secretary of State had regard to the fact that there was an order in Ukraine for the child to live with the father, which,
gone, yeah.
and so a relevant change of circumstances may be the fact that that order has been overturned. For example, I don't know. I mean, it's very difficult for me to say without.
But you say it's possible to envisage situations, particularly on the facts of this case,
yes,
where there might have been a change.
Yes.
It may not just be fraudulent misrepresentation; it could possibly change circumstances.
Well, or it also. I mean, again, I don't know, but it may. I mean, it may well be that the mother, was having to represent the Secretary of State that the protective measures previously proposed by the father were completely inadequate, and wouldn't, that a return was going to be on a certain basis, which, on her submission would expose the child to persecution. But whereas in the context of a very different package of protective measures, I mean, the Secretary of State might be entitled to regard that, in my submission, as a relevant change of circumstances. Again, I'm having to speculate.
But you're saying that you say it's impossible to envisage circumstances, and therefore we shouldn't put too much weight on what they say.
My lord, yes. In other words, it's not solely about misrepresentation. My lord, I would also respectfully refer the court to a provision which isn't referred to by my learned friends in their skeleton argument, which is Article 37 of the Procedures Directive, which is in section, it's in tab 3, section A of the authority bundle, and Article 37 appears at A34.
Sorry, A34.
Yes. And again, Article 37 has the heading withdrawal of refugee status and says member states shall ensure that an examination to withdraw the refugee status of a particular person may commence when new elements or findings are indicated that there are reasons to reconsider the validity of his/her refugee status. And again, that article is specifically referred to in the policy document we've just been looking at. I'd invite you to go to it. I'll give you the reference. It's page C431. And so, in my respectful submission, these provisions do suggest that there is a wider...
I thought so.
Sorry, the computer's talking.
suggests that there's a wider obligation to review the grant of refugee status, which isn't confined to paragraph 339AB of the immigration rules, the rule to which my learned friends draw attention, which specifically refers to cases in which there have been misrepresentations and omissions of fact. So our submission is that in effect, the acknowledgement given by the Secretary of State in G&G was correct, as indeed was the acknowledgement to the same effect given by the Secretary of State in the more recent Scottish decision that also appears in your Lordship's bundle of authorities. At paragraph 42 of my learned friend's skeleton argument, they submit that the Court of Session in the Scottish case erred in
Sorry, Mr. Tyson, I was just noting something else. Paragraph which of the skeleton?
So sorry, so this is the Secretary of State skeleton,
Yeah.
paragraph 42.
42, yeah.
They submit the Secretary of State erred in the passage that's cited there, and submit that a finding as to the best interest of the child could not of itself warrant the consideration of, let alone revocation of, the grant of asylum. We respectfully submit that whilst the best interest of the child is obviously not determinative of an issue relating to asylum, it is a matter which the Secretary of State is obliged to consider as part of her evaluation in this context. And I would respectfully refer the court to paragraph 13 of the Scottish case, which is at tab 9 of the authorities. It has the name "We a Child." Paragraph 13 starts on page B293. The so-called third defender in that case was the Secretary of State, and what you can see there recorded is that.
Sorry, paragraph
13.
Yes, thank you.
She adopted a neutral stance in that particular case, and confirmed a position that had been previously articulated on behalf in the English case of F&M at paragraph 46, which is there quoted. And you can see there that in the subquote at 55, in the context of any such decision, the Secretary of State, one, bears the burden of establishing the requirements of paragraph 339A be met, and two, is required under section 55 of the 2009 Act to take into account as a primary consideration the best interests of the child. Now, of course, section 55 of that Act reflects Article 3.1 of the United Nations Convention on the Rights of the Child, which requires the court to have regard to the interests of the child as a primary consideration, or not just the court, it requires decision makers to have regard to the interests of the child as a primary consideration whenever matters concerning the child are engaged.
So I'm not following this. There are criteria for refugee status. It can never be in the best interest of the child, if those criteria are met, to be sending the child to a state where he's going to be persecuted. I just don't follow it. Best interest of the child is a vital factor when you're exercising discretionary powers in relation to children. But if you're asking whether or not a person satisfies certain criteria whereby sending him to a state will result in persecution or a risk of persecution, I don't understand how best interests can negative that decision. Either the criteria are met or they're not.
We would respectfully submit that as part of an evaluation as to whether the criteria are met, the Secretary of State would be bound to have regard to a reasoned decision of the court, which, amongst other matters, might express a view that the best interests of the child were met by a return to country X.
The Secretary of State couldn't accept that if she thought the criteria were met and the child would be persecuted, no matter what the court said. She couldn't send the child back.
Well, my lord,
it's not a discretionary exercise, the convention, the refugee convention.
My lord, I respectfully accept that proposition. The submission I simply make is that part of the Secretary of State's consideration of whether the test for refugee status is met must inevitably include consideration of a court's reasoned determination that the child's best interest would be met in a certain way. Obviously, if she considers it and ultimately forms her own conclusion that this child would suffer persecution, then I agree, that's the end of the matter.
So you're relying on the material relevant to the discharge of her obligation. That's your
Yes.
submission. Yes.
Then, I promise I'm coming very near to the end of my submissions. Paragraph 35 of my learned friend's skeleton argument. They make submissions about the nature of the Hague Convention process and make a submission that the summary nature of Hague proceedings means they are unsuitable for the resolution of factual disputes or for undertaking risk assessments, even in the context of deciding Article 13b applications. I respectfully submit that this is wrong. First of all, it's very rare for factual disputes to be resolved in a Hague context. The approach generally adopted is that which is summarised in paragraph 36 of Re-E, which is quoted on that page, which is that the court makes the assumption that allegations raised by a respondent are true and proceeds to evaluate the risks, having made that assumption and having regard to protective measures that may be available on a return. The specialist
so far, then, you're agreeing with paragraph 35, are you?
Sorry?
So far, you're agreeing with paragraph 35. You said paragraph 35 was wrong.
Sorry, no, I disagree with the proposition that the essentially summary procedure under the Hague process is unsuitable for making risk assessments in the context of deciding Article 13b applications.
Okay, so it's the risk assessment.
Yes, I agree that it's
because
not...
you agree that on that Hague Convention proceedings are not designed to resolve fact-finding disputes in the traditional sense
Yes.
of, well, I heard from X, I heard from Y, I prefer X.
Yes.
So it's the risk assessment element of it.
I mean, there are some rare circumstances where the courts hear oral evidence and do make findings of fact in a Hague
Generally,
context.
that doesn't happen.
Almost never in an Article 13b context.
So it's the risk assessment point in paragraph 35 with which you take issue.
My lord, yes, I'm sorry. I was being...
No, that's fine. I just...
And so we say, I mean, this is, the specialist judges of the family division do this all the time and are, extremely experienced at assessing risk in this context. And, the process is, we would submit, eminently suited for that purpose. We also do not accept the proposition that there is a very substantial difference between the overall level of risk necessary to trigger the grant of refugee status and a finding under Article 13b to be satisfied. Because although in an asylum context the test is real risk as opposed to grave risk under Article 13b, and ostensibly a real risk is lower than a grave risk, it's important, we submit, that what needs to be established in an asylum context is a real risk of persecution, persecution being a very serious form of harm. And so in this connection, it's relevant in our submission to look at what the Supreme Court said in Re E, which is tab 2 of the authorities bundle, at paragraph 33, which is on page B120. It says, second, the risk to the child must be grave. It's not enough, as in other contexts, such as asylum, that the risk be real. It must have reached such a level of seriousness as to be characterised as grave. Although grave characterises the risk rather than the harm, there is in ordinary language a link between the two. Thus, a relatively low risk of death or really serious injury might properly be qualified as grave, while a higher level of risk might be required for other less serious forms of harm. And so they obviously envisage in this context a sliding scale of risk for the Article 13b test to be met, depending on the nature of the harm alleged. And we would submit that where the harm in question is persecution, obviously that's not quite as serious, not as serious as death, for example, or really serious injury, but nevertheless it's a form of harm towards the higher end of the scale, and therefore in terms of the magnitude of the risk itself, a lower level of risk would probably satisfy the Article 13b test than other less serious forms of harm. At paragraph 37 of my learned friend's skeleton argument, they make the submission that in contrast with the Hague process, where past harm or threats of harm are established, future risk of harm is accepted by the Secretary of State unless there is good reason to consider that it will not be repeated. We respectfully submit that their summary of the position in that paragraph is a gloss on what paragraph 339K of the immigration rules actually says. The rules are behind tab 4 of the authorities bundle, and 339K is at page A53. What is actually said there is the fact that a person has already been subject to persecution or serious harm, or to direct threats of such persecution or harm, will be regarded as a serious indication of the person's well-founded fear of persecution or real risk of suffering serious harm, unless there are good reasons to consider that such persecution or serious harm will not be repeated. And we respectfully submit that actually that's not a million miles away from the sort of approach that the case might adopt in the context of Hague cases, applying the guidance set out in paragraph 36 of Re E. Finally, my own friends make the point that there is a shared duty between asylum applicants and the Secretary of State in terms of gathering evidence, and they refer to paragraph 339.
Where's this?
This is the references in my learned friend's skeleton argument. And I think it's paragraph 36. Well, they speak about the. Sorry, I may have got the wrong reference there. But
37.
37.
Right. Thank you.
What rule are you referring to?
I was going to refer to 339L of the immigration rules.
Where is that?
At page A53 of the authorities bundle, which...
Credibility section.
Sorry?
The credibility rule.
Yes, it makes it clear, this rule, that it's the duty of the person to substantiate the asylum claim or establish that they're a person eligible for humanitarian protection, etc. The duty of the Secretary of State is really is not to substantiate the main part of the claim. It is to obtain relevant country information about the overseas jurisdiction that is up to date, that can be considered by the Secretary of State in the context of the material placed before them by the claimant for asylum, which is a different proposition we would submit from saying that there's a shared duty in terms of evidence gathering. Lord, unless I can assist further, those are the submissions I make on behalf of the appellant.
No, thank you very much. Yes, you're going next.
Oh, yes, sorry. Take my mask off. Caught around my glasses. My Lord, Mrs. Justice Roberts was faced with a situation which both the Court of Appeal's decision and the Supreme Court's decision in G&G were designed to avoid. Their understanding, their hope, their aspiration, quite clearly expressed in the judgments of both courts, was that the two instruments would work in parallel. They would complement each other, both in terms of substance and in terms of process. This case really illustrates the difficulties that can present themselves where they do not operate in that way. It's difficult.
I think, sorry to interrupt you straight away, I think one has to start at the beginning, which is to look at when the claims were made. As I think I said earlier on, the expected course identified in G&G was that both claims would be made, if not simultaneously, they would be running alongside each other. I don't think there was an expectation that an asylum claim would be made after two failed Hague applications. When I say failed, in other words, two successful Hague applications, a committal application, and then some weeks, months later, an asylum claim. That was not. And so they were intended to complement each other because the expectation was they were both going to be being considered by the different authorities in tandem or at the same time. And so that's why it was seen as they would be able to complement each other because they would be being made at the same time. So both would have an eye at what the other was doing, and that no doubt was why one of Lord Stevens's recommendations was that a High Court Family Division judge should determine if they went to a tribunal both parts of or both applications.
Of course, that can't operate where asylum is granted. That can only that appeal process is only available where
it's refused.
Asylum is refused.
Yes,
exactly.
But sorry, go on.
The other oddity here is that she twice went to the High Court, but she didn't tell the High Court everything she told the Home Secretary. So that's the other reason why it's difficult to have them going in tandem, because she's, on one reading, not telling people the same thing.
Well, that may be the case, or there may be all sorts of possible explanations for that. But the stark reality is that this judge was faced with a brother and sister judge in the family division of the High Court, making a different risk assessment albeit at different times, but essentially on similar or at least overlapping material because it relates to a child and the risk of harm, however one looks at the technical criteria for the making of a grant of asylum, which the Home Secretary, the Secretary of State, had made in a completely different way, in the exact opposite direction.
But looking at it from a policy perspective, aren't there advantages if it's made clear to parties that there is an expectation that they should bring forward all their claims at the same time? That is the general rule of civil litigation. You have to bring forward all your claims at the same time. And if one requires a different procedure, as it does in this case, then you have to pursue that different procedure as a general policy consideration for the effective operation, as you said, to complement the process, the substance. The court should expect, as I say, the claims to be brought absent, of course, some new development or new fact or new event. And we are completely in the dark as to whether there is said to be some new development, new factor, new event, which explains why the claims were not advanced at the same time.
That may well be
because you're representing the guardian, so I appreciate you representing the child in this specific case, but of course Kafkas has a broader perspective in looking at the interests of the proper determination of Hague applications when they are made in conjunction with an asylum claim. So I was really inviting your submissions on the broader perspective that there might be good reason for the court to expect a party to bring forward, as I've described it, all their claims at the same time.
Of course, one can see the desirability if that policy objective was adhered to. But the difficulty that this case presents is, what if it isn't? The Secretary of State can't refuse to deal with a tactical asylum claim simply because it's been made after not only a substantive summary return decision by Mr. Peel, as he then was, but also upheld by various other judges, refusing, in this case, the mother's applications for stays and for set-asides of that very same order. But
we're not talking about the Secretary of State. We're talking about the family, the civil court. We're talking about what the response should be. Of course, the Secretary of State can't refuse to determine an application that's been made. But the question is, how does this court, how does the family court respond to, I mean, you've described it as a tactical claim. There might be a tactical claim. How does the court respond to that situation?
Essentially, it has to recognise that the Secretary of State has made a decision within that exclusive environment, which is entirely her decision in accordance with a completely distinct set of rules as ultimately set out by Parliament. And the short answer to my Lord's question is that this judge did what we submit is exactly the right and appropriate way of dealing with the dilemma that she was faced with. She couldn't gainsay the tactical device of the mother. She had to deal with it and deal with the consequences of it, which were that the Secretary of State had essentially taken a different view of risk to what the High Court had and granted asylum.
Because we don't know the reasons that asylum was granted.
Well,
we can't have any submissions based on what the decision was because we don't know. We're not being told.
No.
It's secret squirrel. So, therefore, you can't make any submissions about what the Secretary of State decided because it's secret.
Well, that's the asylum. That's the asylum apparatus.
My Lord's question was all about the convention and the proceedings under that, and your answer is effectively tough. You're stuck with it.
Well,
as a court, you're tough. You're stuck with it.
The judge below was stuck with the decision of the Secretary of State to grant asylum, whatever the reasons, whatever the material that she was shown, however monstrous that material might have been. Mrs. Justice Roberts was, with respect, stuck with the fact of the grant of asylum.
Why was the judge given the asylum material? For what purpose?
I think there were case management reasons that have to be traced through quite carefully. Broadly, she was dealing with an application for disclosure by the father. And that hearing in June, which is the 30th of June, was set up on the 14th of May. I can take my lord through
everybody has the
orders.
material, apart from one parent.
And
that material was given to the judge, I assume, because it was thought to be relevant to the decision she was making.
Well, she was given it because she had made a case management direction prior to the grant of asylum, prior to the communication of the decision of the Secretary of State to the parties. That they were made, those case management decisions were made in May of this year.
That the material should be disclosed.
That if there was to be any dispute about the disclosability or the availability for inspection of that material, then yes, it would be made available to the trial judge for that purpose. My lord.
I understand the point about you're stuck in terms of enforcement, whether one likes it or not. The Secretary of State has made the decision and the child cannot go back. But we're at a different stage here, which is to set aside the redetermination of the Hague application. If things had gone as the indication is it should have gone, the mother would have said at the time she made her response to the first Hague application, she would have given the information about the allegations she later told to the Secretary of State. The court would have considered them in line with G and G. They would have said whether or not those allegations met the threshold, and the Secretary of State didn't have it. But what happened here, apparently, was that the mother didn't tell the court everything. She lost twice. She then made an application for asylum on, it appears, from as far as we can tell, different information. So whilst I'm fully sympathetic to the fact that the court is stuck with the decision, does that mean that you don't have a full rehearing of the application on all the relevant information, as Mr. Harrison outlined, for the purposes of deciding whether the Convention articles would apply if she told the court that in the first place?
Well, our short answer is yes, you don't need the full, all guns blazing type of final determination of a Hague Convention application.
Why should a parent ever cooperate then? Why should a parent ever put forward its reasons for resisting an application to return the child? Why not keep some of them just in case?
Well, that's the difficulty with the way that the asylum process operates. But I go back to my core submission. I'm afraid that there's a grant of asylum, and that was what this judge was faced with. She was fully aware, of course, of the history of the proceedings, and no doubt had formed the obvious view that a High Court judge exercising a family jurisdiction would make of the mother's tactical manoeuvrings. And I don't just include her application for asylum made on behalf of the child, but also all the other attempts that she had made subsequent to the return order to try and set aside, to try and stay the orders. But she's faced inevitably with the grant of asylum by the Secretary of State. And that...
Sorry.
I'm so sorry.
No, I didn't finish your sentence. I don't want to go to this end, mid-sentence.
There's a lot more to say, but...
well, perhaps do stop there, and you can make... I mean, unless you want... What do you want to say?
Can I just conclude it?
Yeah.
That regardless of... And I'll come on to deal with the process that my Lord raised, first of all, with my learned friend. But that made it, we would submit, inevitable that she was going to conclude the Hague Convention proceedings. And I appreciate I have to elaborate on conclude.
Thank you very much. We'll start again at 2:05.
Thank you.